We're starting to see some legal disputes now between different types of media organizations. On the one side, you have the media companies that are content providers, people that spend a lot of time and money and resources in creating content. And on the other side of the coin, there are companies that are trying to take advantage of that content. For example, you get what's called aggregators, people that will take content in a particular area that might be of interest to you. And the question is whether or not the aggregators have to pay for that content that they're using, or whether what they're doing is fair use. For example, there's a case involving a company called Aereo, which has provided a sort of a new technology that allows you to get your over-the-air free television signals. They analogize it to an antenna. One case was filed in Utah, and in that case, the networks that brought the case against Aereo won the case. The second case was filed in New York City. And in that case, the Court of Appeals ruled in favor of Aereo, and that decision has now been accepted for review by the United States Supreme Court. You know, this is not a whole lot of difference than somebody putting up a big television screen in Central Park and charging $5 for 100,000 people to watch NCIS or Two Broke Girls or whatever it may be. The consequences for the broadcasters are a little more far-reaching. This technology that Aereo is employing can be employed by others. And so if it's okay for Aereo, you know, maybe the cable companies can start to use this to circumvent retransmission fees to the broadcaster. So a loss for the networks, pretty wide-ranging and long implications. If Aereo loses in the United States Supreme Court, it's probably the end of their business model.